The project went to air in February 2021, and unless you're living under a very heavy rock or had been stuck overseas during the pandemic, and even then, you would not have failed to have been aware of this allegation or this, from the media's perspective, story. What made it a very important matter for us to act for Bruce was, without having met him, without knowing anything about the case, as at the time we were asked to act for him, certainly my perception was that this was Alice in Wonderland, sentence first or verdict first, trial later, because there was so much material out there that was just simply, he's guilty and we've just got to go through this process of a trial. I saw that as a significant undermining of the rule of law and the presumption of innocence and due process, and I wanted to be part of an attempt to at least give this man a fair trial in the face of what I and many other people had considered was such adverse publicity that he could never actually get a fair trial. If Ms Wilkinson had not said the things she said at the Logies and the trial judge had not adjourned the trial for 3 months, I genuinely believe Bruce would have been convicted. What happened at the Logies and what was said is the matter of some contention and discussion at the inquiry, so I won't say anything about what was said, but it's a matter of public record that as a result of what was said, we made an application for a temporary stay. That it wasn't fair, on top of everything else, for Bruce to have to face a jury a week after, on one interpretation. There were public statements again, basically saying Miss Higgins is a true victim of a true crime and the trial is just a formality. So we said we needed to have some time, we needed to stay in order to put some distance from that speech in the minds of any potential jurors. And the Chief Justice agreed and the trial was put off for 3 months. If it wasn't for Ms Wilkinson's speech, we would have gone into that trial without so much material that we subsequently came into possession of, either through chasing up disclosure or chasing up subpoenas, that was integral to properly understanding and challenging the complainant's allegations. There's no such thing as jury whispering. I've done criminal trials or been involved in them for over 30 years, and I've never known what a verdict would be, but it's almost like something that everybody does. We spend our entire lives and the trial dealing with admissible evidence, probative evidence, but then as soon as a jury goes out to consider its verdict, we all think we're experts at determining, because someone raised an eyebrow or sat in a different seat or giggled at some comment, that we know what they're thinking. And that's just, it's just not true. I was always concerned that because of the pre-trial publicity, because there were so many people who were exposed to and influenced by the pre-trial publicity, that we would struggle to get necessarily 12 unbiased, unaffected jurors. And in some respects that was borne out by the number of people in the jury pool who, quite properly, when the Chief Justice asked that anyone who thought they might have some pre-existing bias, either for or against the complainant or the accused, or had attended the March for Justice or subscribed to particular views about sexual assault, or even had own experiences that meant that they could not bring a fair mind to the role of a juror, to come forward. And a lot of people did. But we were never able to be sure that some of the people who didn't come forward may have had strongly held views and were going to not come forward because they wanted to ensure justice as they perceived it would be done. I gave evidence in relation to my perceptions of concerns about the Victims of Crime Commissioner having, walked in and out of court with Ms Higgins. It's one of the terms of reference, and it's, one that I anticipate there will be evidence about. I did not have any personal dealings with, and I certainly have not got any beef with the Victims of Crime Commissioner or that office, or the important work that they do in supporting people who are asserting that they are victims of crime. The problem in this case, and it's not just my perception, it's one that I know a lot of people have shared, is that by walking next to Ms Higgins into court every day, as the statutory office holder of the position of the victims of crime, and that would be videoed every morning, it would be in the papers and the news that night, it carried with it a less than subtle and a less than subconscious inference that Ms Higgins was in fact a victim. It was about as subtle as if Ms Yates had walked in with a t-shirt, wearing a t-shirt saying Bruce is guilty. If I was ever going to write a book about this experience or this case or anything about it, I think I'd call it Throwaway Phrases, because it really does sum up what this case has demonstrated, in my view, in relation to what was more an insidious and underappreciated issue, which is this conflict and this tension and this slow bracket creep between the presumption of innocence on the one hand and believe all women, or in a sexual assault people don't make anything up, and to the undermining of a presumption of innocence. Due process and the presumption of innocence are not throwaway phrases. They are the cornerstones of the rule of law. And if we want to have a debate about what the presumptions should be, whether there should be an onus of proof, whether an accused person should not have a right to silence, those things should actually happen in an informed way publicly, rather than this insidious suggestion that that's what the system is, but it's not good, it's not right, and let's really just not take any notice of it.